the legislation in front of us. And with that, the microphone is yours. Thank you. Representative Mandarino, Representative Stevenson, thank you for inviting us to be here today. Our two branches of government very much need to work together collegially and for the best interests of the people of Pennsylvania, and that doesn't happen enough. I think just through sort of benign neglect. We don't think to call each other and talk enough, and so it's very, very important that we're here. We appreciate it. Let me also say that I speak only for myself. If you follow our court's jurisprudence, there's rarely unanimity about anything as we write, and so I'm giving you my views. I have not run this by the court. I've not asked the court for a view, so I don't speak on behalf of the court. And before I talk about custody, I want to respond very, very briefly to the thoughtful comments of Representative Baker. Most of what you said are wonderful ideas. And my comment is to bridge this seeming inadvertent gap between our branches of government. I'm not sure, I don't think we need a constitutional amendment, and I'm not even sure we need a bill. I think if we sat down and talked about it, a great deal of what you're suggesting could be done through procedural rule, and I would not be opposed to that personally, because I think a lot of what you suggested are good ideas and worthy ideas to flesh out and talk about. So I make that invitation. It'd be my pleasure to do that, and it'd be my pleasure on behalf of the judicial branch to bring it to the table to talk about those things. I'd say the same thing regarding your statute, which I did read, and it's got good ideas in it. So I wanted to flesh that out, because sometimes we don't have to go to Harrisburg and pass a law to get things done. Let me talk about custody for a second. And I have Sandy, who Representative Mandarino was nice enough to introduce, keeping a clock on me, because like all of you, I'm not good at containing myself at the microphone. And what I want to do is try to go beyond the current bills and talk about what a system that pulls on research and experience in other states might look like in about 15 minutes or so, leaving a few minutes for Sandy to comment, and then leaving lots of time for questions and dialogue between us, which I think would be helpful. Obviously, the criteria for custody now is best interest of the child. And that criteria is justifiably, in my view, criticized as being so amorphous as to not be helpful when these very difficult issues come before the individual judge. And indeed, too often leave it to the personal instincts, biases of the individual judge, as best interest can be anything you want it to be. So the question then becomes, what do you supplant it with? Or do you have to supplant it? That question, I think, though, needs to be delved into even more. What are the societal goals that the legislature seeks to meet, and how to best meet them when it comes to custody? I think that there'd be no controversy from anybody in this room that the goal is healthy, normal children developing into healthy, normal adults who lead productive lives and add to society. I think to do that, we need a child-focused system. I think people pay lip service to child-focused systems, but really have great difficulty trying to get there. We always hear, and we've already heard today, about fathers' rights. Fathers absolutely have rights. They have a constitutional right to raise their children, explicitly acknowledged by the U.S. Supreme Court. Hear about moms' rights. They have the same rights, co-equal rights. But I'd suggest respectfully that those rights are subservient to a child's absolute right to life, liberty, and the pursuit of happiness, to a child's right to grow into a healthy teenager, healthy adult. So I think we need to be child-focused and not mom-focused and not father-focused. Now, I am very shortly going to constructively, I hope, criticize presumptive joint custody, because the experience around the United States, and indeed around the world, is that it doesn't work. But before I do that, I want to be careful that I don't paint with too broad a brush. We know that the single most important factor We know this from research, and I'm glad to supply that research for you. I do have it, and I did review it before coming in here today. The single most important factor in a child's success in growing into that healthy teenager or adult is the reduction of parental conflict. Conversely, or said a different way, when you have high parental conflict, children are most at risk. When you have low parental conflict, post-separation, post-divorce, children do best. So the real goal, I think, of legislation and the real goal of the judicial system to be child-focused is to reduce the high level of conflict between parents. Because those parents without high levels of conflict don't need us. They don't need a law. They don't need a court system. They separate and they raise their kids, and their kids grow up healthy. So we're really legislating and really adjudicating for the high conflict or the moderate conflict cases. They're really the high conflict cases. So in terms of child focus, it's as simple as the old story of Solomon. You want the child to go with the mother who would let the child go with the imposter, and not the mother who would cut the child in half to have their half. And that's what we're looking for. High conflict cases, then, I think have to be the focus. And the reason being that they put children in just terrible tension. You know, when they're infants, some parents will never let them cry, other parents let them cry themselves to bed. I'm not here to tell you which is best, but I'm telling you that the child should have consistency. Different bedtimes, different rules of opening your refrigerator, homework, and different levels of parental activity or getting homework like curfews. And I promise you, I've seen all of these more egregious scenarios where mom and dad have their own doctors. And when Dr. A says flu for dad, mom takes the child to her doctor to confirm or not confirm. Different dentists. Mom and dad are of different faiths or even different sub-faiths. And when child with dad, child goes to dad's church. When child with mom, child goes to mom's church. And if the child's confused, that's too bad because that's their constitutional right. This puts kids at risk, and again, we know this, for everything. For mental health disorders, for depression, for substance abuse. As they get older, for homelessness, for suicidal tendencies. It puts them at risk for education failure, maladjustment, and inability to form their own relationships. What it does is, in too short a time, as those of us who are older now know, has them repeat the sins of their parents. Inability to form relationships, maintain relationships. So, if the difficulty is the high conflict cases, and the solution is to dissipate that high level of stress and that high level of conflict, the question is, how do you do it? Let me start very briefly, because I know that it's front and center today, and that many people, good people, will be providing testimony with what I think is not the answer, respectfully, and that is presumptive joint custody. If the most important goal is the reduction of stress, then those who advocate presumptive joint custody in high conflict cases must think it's going to reduce stress, or else they'd be child focused, or they wouldn't be advocating it. There are many, many advantages to joint custody. Indeed, the research shows it's the best relationship for kids, but the research is always based upon low conflict cases. Mom and dad separate, and mom and dad never come to court. They come to court once because they've got to get things straightened away. They never get the lawyers, open the statutes, and engage in that high conflict litigation. They reach an agreement that they're going to co-parent their kids. Their kids have the best success rates. That system of joint custody works. However, when you get to the high conflict cases, it doesn't work. And again, the research shows that it doesn't work. And in some ways, it's intuitive that it can't work. But when you go back to the research, which is always worthwhile, there's a statistical correlation between court-ordered joint custody and its failure. In other words, as I said, parties reach it themselves, it works, it's a success. Courts order it, it's